All right. Okay, let's go on the record. The time is 2:09 p.m. This is a public hearing for Deschutes County file numbers 24726120120PA and 121ZC. My name is Tommy Brooks, and I am the hearings officer in this matter. Please note that there were two separate hearings scheduled today. This is the hearing, the one we're starting now is the hearing only for Deschutes County files 120PA and 121ZC. If your interest is in the other application, which is file numbers 537PA and 538ZC, you will need to refer to my instructions in that case to determine whether and how you may participate in that proceeding. We are holding this hearing in part through electronic means, so before we begin, I'm going to turn things over to Ms. House to describe how the hearing process will work.
Right. Good afternoon again. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. This hearing will follow the same procedures that I previously outlined, but I will go over them again, and just in case there were any questions. So I'll again start with the hearing format and explain how to testify today. I'll then present a brief staff report. Then we'll move on to the testimony portion of the hearing. The applicant will testify first. They will have 3 minutes. Then persons in support will have 3 minutes. And then those in opposition will have 3 minutes. After that, the applicant will have an opportunity for rebuttal. They will have 10 minutes. And lastly, staff can make closing comments. And as previously noted, the hearings officer can modify or eliminate those time limits at his discretion. So today's a hybrid hearing, both in-person and remote participation is allowed. I'm going to pause and just ask, is there anyone on remotely right now? So looks like no one's attending remotely. But if you are testifying, please make sure to state your first name and last name, as well as providing your mailing address for the record. For in-person participants, I will call you up to testify here at the desk. Please speak clearly into the microphone and make sure you've added your name and contact information to the sign-in sheet. I'm going to not go over these procedures because, again, there's no one attending remotely. So in addition to testifying today in person, you can also provide written testimony. To do that, just hand it to me if you're here in the room. And if you're later listening to this online, please email any submittals you have to caroline@deschutes.org. And I do want to note for the record, there was some type of form letter that was generated that misspelled my name. And I do want to note that my name is spelled Caroline, and my last name .house, so HOUSE @deschutes.org is the correct email to use if you want to submit electronic submittals. Hearings Officer Brooks and myself are responsible for an orderly and respectful hearing. If you're being disruptive, you may be asked to leave. And I will say, just if you can try to keep any sounds or chuckles if you are in disagreement with somebody that's speaking, keep those, I guess, to yourself, just to be respectful to who's testifying. And lastly, I'll pause now and ask if there are any objections to the hearing format that was just described. All right, hearing none, I'll turn it back to you, Hearings Officer Brooks.
All right, thank you, Ms. House. The process staff just described is the normal hearing procedure set forth in the county's code, and I will make sure to provide sufficient opportunity for everyone to participate at the appropriate time. The application is being considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to the hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website and are available directly from staff upon request. It's important that you direct all of your testimony only to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why that criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. As I mentioned, there were two hearings today. Some participants have already submitted comments to the record, and in doing so, they addressed both applications. It's my job to ensure that the record is clear for each of these applications and that I apply the unique facts of each record to the applicable criteria. So when you're testifying, it is important to me and to the process that you address only the application that is the subject of this hearing. And please do not assume that the comments you make are equally applicable to both applications that were scheduled for hearing today. If I cannot tell which application you're addressing or which criteria you are speaking to, I will not be able to address your comments. The failure to raise an issue with enough detail that enables me or other participants to respond to that issue precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again, with enough detail that allows me to respond to the issue, precludes an action for damages in circuit court. In my role as hearings officer, I serve as a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant, and I am not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff about the procedural aspects of today's hearing, but not the substance of the application, and I do not have any ex parte context to disclose. I hear from you, Ms. House, that we don't have anybody, or maybe we do have one attendee online. And are there people in the room who wish to testify?
Yeah, it does look like someone just joined online, and there's at least 2 people, I believe, that will testify in person that are not part of the applicant's team.
Okay, so again, it sounds like we'll be able to manage the time pretty well. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? If you're in the room, you can signal to Ms. House. If you're online, you can hit the raise hand function.
No objections.
Okay, so with that, let's proceed to staff's presentation.
Okay, so for this second hearing today, the subject property is assigned address 68589 Highway 20. This property is 64 acres in size, and the owner and applicant are R. Derek Jaros, LLC. So the applicant, again, is requesting a comprehensive plan amendment to redesignate the property from agricultural to rural residential exception area. And they're also requesting a corresponding zone change to rezone the property from exclusive farm use to multiple use agricultural. And no exceptions to any of the statewide planning goals are proposed. Similar to the first hearing, there's 2 potential issue areas that staff is asking the hearings officer to focus his review. The first is compliance with statewide planning goal 3, which is related to agricultural lands. So staff is asking for the hearings officer to confirm whether or not the property meets the definition of agricultural land under the applicable Oregon administrative rule. And staff is also asking the hearings officer to determine whether the property is necessary to permit farm practices on adjacent or nearby lands. In support of the application, the applicant has provided an Order 1 soil study. They have significant expert testimony about attempted farm uses on the subject property, and they have other detailed information to demonstrate that the subject property is not agricultural land. For potential issue area 2, this is related to compliance with statewide planning goal 5, and the property being partially located in the inventory goal 5 Highway 20 landscape management roadway scenic resource. So on the screen here on the right is the portion of the property is identified in that hatched blue color. That's the part that's within that designated corridor. And then on the left is a partial view of the property from Google Maps. So part of the review or determining compliance with statewide planning goal 5 has to do with addressing whether the new uses allowed in the MUA 10 zone may conflict with the scenic resource in this case. And our current analysis identifies conflicting uses as development within the 1/4 mile overlay zone, which would excessively interfere with the scenic or natural appearance of the landscape as seen from the road, or alteration of existing landscape by removal of vegetative cover. So in support of the applicant has provided a site-specific EC analysis, and my understanding of their argument is that the current protections of the LM combining zone are sufficient to continue to protect that scenic resource. All materials, I did see between the break, I did receive one, I think, additional comment, which was a form letter, but no other materials or everything else, I should say, has been uploaded into the record and is available at the website on the screen. And that concludes everything I have, but I am available for questions from the hearings officer.
Okay, thank you, Ms. House. I don't have any questions for staff at the moment, so we can proceed with the applicant's presentation.
Thank you. Good afternoon. My name is Tia Lewis, and I'm the attorney for the applicant, Derek Jaros, in this case. With me at the table is Daniel Robinson, the planner that we have on staff to help put this application together, as well as the applicant, Derek Jaros. I do have a PowerPoint, and I don't have the ability to control it, so bear with me. I'm going to have to tell people to advance it. As Ms. House indicated, the subject property is 64 acres. We can go ahead actually and advance it to the next slide. Thank you. And the key facts are stated right here on this this slide. It is adjacent to the City of Sisters UGB and the city limits. It is adjacent also to the City of Sisters wastewater treatment plant to the west and the Deschutes National Forest to the south. And then approximately 231 acres adjacent both to the east and the southeast are owned by the City of Sisters, which are planned for eventual use in conjunction with their wastewater treatment system. 45 of the acres are currently being irrigated with effluent, and the city has indicated that they plan to spray effluent on at least some portion of the additional acreage. To the north, across Highway 20 is Hawks Haven Reserve, which is a wildlife reserve comprising of 90 acres. And it was formerly a part of the Lazy Z Ranch, as was the property that was the subject of the hearing just prior to this one, owned by Willits LLC, and is also the subject of a plan amendment zone change to go to MUA 10 like the subject property. We could advance to the next slide. As previously indicated, this property was formerly a part of the Lazy Z Ranch, approximately a 1,400-acre ranch that was operated between 1999 and 2016. We have extensive testimony about the operation of this ranch, the expense to operate it, and why it ultimately failed in Exhibit U. And that testimony is that testimony comes from the ranch manager who managed the ranch during the period of time in question and who testified to the expense to operate the ranch and how much that expense outweighed any reasonable rate of return. The applicant purchased the property in 2011. Prior to that time, the water rights that were on the property were transferred in stream to save the Wychus Creek. They were transferred in stream in 2009, and I think that most of the people that live around here believe that that was a much better use for that irrigation water than to put it on unproductive ground. We have no development proposed with the present application. The applicant does have a single-family dwelling approved for the southeast portion of the property outside of the LM zone. If we could advance to the next slide. We did do an Order 1 soils report that establishes that the property is predominantly Class 7 and 8 soils, 64%. That report is in the record as Exhibit I. We additionally did a forest land productivity analysis to confirm the property does not qualify as forest land under Goal 4. That report is Exhibit Y. We have extensive testimony, again, in the record about the property owner attempting farming efforts, seasonal grazing, and soil regeneration, again, at Exhibit U with Hobbs Marguerite. And the transportation analysis confirms that the subject property is in compliance with the transportation planning rule and does not significantly affect a transportation facility. And finally, we performed an EC analysis to establish that the new uses allowed under the MUA 10 zone will not conflict with the Goal 5 resources. So now I'll briefly go over that evidence that I just talked about. Oh, thank you. So the first category of evidence is the evidence addressing agricultural land, and there's a number of factors that go into demonstrating that the subject property is not agricultural land. The first step is the definitional factor. The agricultural land in Deschutes County is predominantly Class 1 through 6 soils. ORS 215.211 establishes that the site-specific soil study is acceptable to establish whether or not land qualifies as agricultural land. Our Order 1 soil survey establishes that the property is predominantly Class 7 and 8 soils. That's in Exhibit I, and that's our soils report. Gary Kitzrow dug 41 test pits on the 64-acre site and confirmed that over 40 acres of the subject property is Class 7 and 8 soils, resulting in the 64% designation. The next factor under this analysis are what's called the suitability factors, and those are found at OAR 660.030.00201AB. And those are the factors that discuss climatic conditions, soil, water retention, the availability of water, energy, inputs, and the ability to amend the soil, and additionally, as well as accepted farm practices in the community. Not any one of those factors are determinative, and they are all a part of a balancing test to determine whether or not the farm use is available on the subject property. The soil examiner addressed these suitability factors in his report at pages 4 through 8 of Exhibit I, and the Exhibit U testimony additionally addresses the suitability factors, finding that the subject property does not have sufficient soils or water retention or the availability of water, and that any energy and inputs into making the subject property farmable, the cost of far outweighs any return that you could get on the property. And there is an element of profitability in the farm definition. It does require the kind of efforts that a reasonable farmer would take in order to engage in farm activities on the property. The next element of the Goal 3 analysis is the necessary for farm use. And what the rule states is that land qualifies as ag land if it is necessary to permit farm practices on adjacent or nearby lands. The cases that we've cited from LUBA has interpreted this as a high standard, meaning that not only the land itself has to be necessary to permit agricultural practices on adjacent or nearby land, but the retention of an EFU zoning category has to be necessary to permit agricultural practices on adjacent or nearby lands. And as we have established, there are very few agricultural practices in this area. The property to the west is within the Sisters UGB and city limits. The property to the south is either forest land or owned by the City of Sisters being used for their wastewater treatment facilities. The property across Highway 20 is, first of all, separated by Highway 20, and second of all, in a conservation wildlife use. There is some mead production on what was formerly a part of the Lazy Z Ranch, and again, that is being conducted in relationship to a commercial use in conjunction with farm use. And that application itself had to establish that the commercial use would not interfere with agricultural uses in the area. Like the applicant before us, we believe that the MUA 10 zoning is significantly less intensive than a commercial use, and the same evidence that establishes that commercial use is not going to interfere with the ability of farm activity in the area to continue is relevant to the question in the present case. And then lastly, the analysis under the administrative rule requires that the property not be a part of a farm unit. And as we've indicated, this property was a part of a farm unit at one time when it was a part of the Lazy Z Ranch. That ranch was split up many years ago, over 15. There's not been irrigation water on the subject property in over 15 years, and there's not been farm use conducted on it or properties that are adjacent or contiguous with it in any sort of farm unit fashion. So let's move on to the next issue. This is the Goal 5 program. So Deschutes County's Goal 5 program is found in Chapter 2 of the Comprehensive Plan and implemented through, in this case, the Landscape Management Zone. Chapter 2 of the Deschutes County Comprehensive Plan is the resource management chapter, and it identifies the county resources that they want to protect under Goal 5 and sets the purpose and to manage those resources sustainably, which encourages balancing economic, environmental, and social concerns. Chapter 2 lists those resources that the county identified, and those include agricultural land, forest land, water, wildlife, open space, scenic views, energy, environmental, quality, mineral and aggregate resources, and historic and cultural resources. In our circumstance, what's implicated is the scenic view resource, which is governed by Section 2.7. Section 2.7 in the comprehensive plan governs open space, scenic views, and sites. And Section 2.7 very clearly makes a distinction between open space as a resource and scenic views as a resource. Open space as a resource is protected through the Open Space and Conservation Zone in Deschutes County, which currently which in 2009 comprised over 70,000 acres. The scenic view resource is protected through the landscape management overlay zone, which is implicated in the present case. The subject property does contain a quarter mile in from Highway 20 into the subject property is the landscape management zone, and I'll show it on a slide in a minute. But when the county inventoried these scenic resources, and the last time they did this was during periodic review, which occurred from, by the way, 1988 through 2003, but they identified 32 road segments for LM protection when they did that scenic resource inventory, and Highway 20 was one of the road segments that was identified for protection. This Goal 5 implementation program is implemented through the landscape management combining zone. And throughout the Goal 5 protection program, it is clear that the focus is on balancing conflicting rights of property owners and resource values. It is not on, in the sense of the landscape management zone, it is not on prohibiting development, but focusing on incentives and mitigation and obscuring the visual impacts of development. The landscape management zone is found at Chapter 18.84, and in the present case, every structure that would be applied for in the landscape management zone would be a visible structure because there is not intervening vegetation, and so that requires the highest level of review under the landscape management zone, including design review and increased setbacks. If we can move to the next slide. Consistent with the LUBA case law on this matter, the applicant performed an EC to demonstrate compliance with Goal 5. And as a part of that EC, the applicant submitted the 1992 EC performed by Deschutes County when the LM zone was adopted to establish the baseline for the scenic view protection in the county's program to achieve the goal. That 1992 EC is at the back of our site-specific EC submitted as Exhibit G. And as a part of our site-specific Goal 5 EC, we studied the uses that would be allowed in the MUA-10 zone, which are not allowed in the EFU zone, to conclude that those uses would not conflict with the Goal 5 resource, which is the view from Highway 20, subject to the continued LM provisions. And let's advance to the next slide if we could. So in order to study the MUA-10 uses, the applicant chose an impact area based on the scenic views. So we're talking about Highway 20, which has a vehicle speed right here at 55 miles an hour. And the impact area extends 3/4 of a mile along Highway 20 to where there's a curve in the road and you can no longer see the subject property. So that was the scope of the EC when it examined the social, environmental, energy, and what did I miss? Social. What was it? Social, environmental, economic, and energy consequences of allowing the uses in the MUA-10 zone that were not allowed in the EFU. And then if we can click to the next slide, this shows the checkerboard pattern of the Highway 20 corridor, which is the scenic corridor we're talking about. And there's a significant amount of MUA 10 zoning within that corridor. And so the types of uses that would be allowed on the subject property are the same types of uses that are allowed in those MUA 10s within the zoning corridor. Okay, yeah, next slide. Thank you. And so lastly, I just had this slide to go over what the rezoning standards are. And I'm going to be brief on these because they are addressed in detail in the burden of proof as well as throughout the exhibits. The change conforms with the comprehensive plan in the plan's introductory statements. The applicant has addressed that in pages 7 through 18 of the burden of proof. The plan prioritizes the protection of high-value farmland, and that is not what this property is, and the evidence in the record overwhelmingly establishes that. That the change is consistent with the purpose of the MUA 10 zone, and the use of this property couldn't be more consistent with the purpose of the MUA 10 zone. The MUA 10 zone's purpose is to preserve the rural character of the area while permitting development consistent with that character and the carrying capacity of the land. It's also to maintain and improve the quality of air, water, and land resources, and to establish standards and procedures for the use of those lands designated unsuitable for intense development and unsuitable for commercial farming. So then the next factor is that the change in zoning will preserve the public health and safety and welfare, considering the availability of and providing necessary public services. We've addressed that in on pages 19 of the burden of proof. The property is served by sewer and well water, and it has power from Central Electric Cooperative. It has sufficient transportation access through Highway 20. It's served by the Deschutes County Sheriff and the Camp Sherman Fire District. The impacts on the surrounding land will be consistent with the goals and policies of the comprehensive plan. The subject property has planned to be used very similarly to the surrounding land. And then lastly, that there was a change in circumstances since the property was zoned. And there's really not much that hasn't changed since the property was zoned in the 70s. The prior failure of any farm use of the property and the continued efforts to farm it, as well as the surrounding development and the establishment that the soils are insufficient for any sort of agricultural use, represents a significant change in circumstances. I do have my client that would like to testify briefly about the activities that he's undertaken to try to farm this property. We do want to reserve a brief opportunity for rebuttal and to discuss any post-hearing open record periods. And we'd be happy to answer any questions the hearings officer may have.
Okay, thank you. Yeah, I'll let the applicant's representatives continue.
Thank you.
Good afternoon. I'm Derek Jaros. My family and I own the 64 acres at 68589 Highway 20 in Sisters, Oregon. We have a 1920s farmhouse on that property that sits next to the road. Our kids live in that house and have been on that property for several years now. You know, in the last 15 years since we've owned this property, we have tried to lease it out to those that can run cattle successfully, that know the business. We've had 4 people take a shot. None of them have extended a lease more than a year. There is so little to graze on. The season is so short. We have no water rights, so we can't help them out there. And it's been a kind of dismal failure. It has never continued on, and we have had no luck in getting anyone stay on long term. As far as the soils go, you know, the USGS maps have them mapped as 5s and 6s. Our soil tests showed that they're not. They're 7s and 8s, and they don't qualify as ag soil. It kind of reinforced the reason why no one can successfully graze on this property for any period of time, any more than a couple weeks in the spring. So we've also, during that time, of the people we leased to, we mentioned Hobbs Margette. He's an expert regenerative farming. He tried his best during a period. We were going to do a 2 to 3 year period, but failed so miserably the first year that he chose and we chose not to carry on. Of all the seeds and forbs, everything that was put into ground, nothing came up on 98% of the property. A teeny bit came up on 2 acres. Nothing came up the second year. It just didn't work. And the soil tests that we've had since that time by Gary have shown why it didn't work. Our soils were tremendously worse than what the map said. So, right now, what I really want to have is I want to have this property zone to align with the actual property characteristics, not the ones that show on paper that are incorrect because they don't apply. And his firsthand look into the ground, looking under the hood, shows that. We would, this is a family ordeal. I'm not a developer. I've never changed zoning. I've never done any development in this city. It's a family farm and our family's out there. We'd love to have other family members live on this property too. It's never going to happen under ag zoning, which is incorrect. So, I'd just like to say that, I have no plans for this property. I'm not going to come to you with a big development proposal or anything like that. We want it to change so we continue to use it as a family property. So a couple of things I do want to say. We got a copy of the land use flyer soliciting the 320 responses. And I showed it to my wife and she read it and she goes, they can't say those things, can they? They're not true. They stated we have water rights. We do not have any water rights. There just aren't any to apply to that property. They called it spot zoning. Spot zoning is a term they use when, say you have 700 acres out in Terrebonne in the middle of nowhere and you're trying to make 10-acre parcels. Well, we're doing this on the city fringe. In fact, in those cases, the land use groups argue that that's where this should happen. Well, that's what we're proposing. That's where this should happen. Orderly transition on the city fringe, urban growth boundary fringe. We're not asking for a bunch of development here. They noted also, possible violation of Goal 5. I'm sorry, but there's no way we can violate that. It's in place. It's in place on zonings that we're requesting up and down Highway 20, and it is compatible. We're not suggesting to do anything that would degrade the scenery. I'm all in favor for that. And I have to say, I'm a former Land Watch member in Lane County when I lived there, when I renovated farms like this one that we're renovating. We spent a lot of money getting this house that sat vacant for 10 years back up to snuff and working again. And we're trying to make it a farm ag project, but it is physically impossible. It isn't going to happen. So I'm asking you to take a look at the real facts. And also consider that when they set this flyer out, they sent it out with a picture of city property with their bronze horses. That's on property that the city owns that's protected on what they call the Lazy Z master plan. It was very misleading. That's not our property. So again, they misled to get 320 responses. So are those responses valid? I really need to know that, because they were not factual in what they sent out. So I would like the hearings officer to take a look at the actual facts of what our property is, what it's capable of, and make a decision on getting this zoning request approved. We think it meets all state goals, and I hope that's what you find.
Thank you. That concludes the applicant's presentation.
Okay, you'll of course be able to come back up for rebuttal if needed. So, Ms. House, can you identify if anyone who signed up to testify is going to do so in support of the application?
Is there anyone in support in the room? There is one person.
Officer Brooks. Officer Brooks, my name is Greg Willits. I reside at 69500 Green Ridge Loop in Sisters, Oregon, and I'm here in support of this application. We are not talking about agricultural land here. It is clearly not viable farm property. Existing conditions do not support meaningful or profitable in any way ag use. There are poor soils here, low agricultural productivity, unsuitable for sustainable farm operations. Limited water rights. Water constraints further limit this viability. Cost of water rights is a significant obstacle to agricultural use. They're exceptionally expensive and prohibitive, in my opinion. There are examples. Hobbs Margaret came to our family with the notion that he could regeneratively farm this land. And he came with such excitement that we were instant believers in his process and held out tremendous hope. And I don't know if he lasted a month after saying he could produce seed into an item that a cattle would graze on. And he never came back as identifying it as futile, in his opinion. In addition, the Jaros property is surrounded by other urban uses. The city operates public facility sewage ponds and reclaimed groundwater recharge southwest and east. Parcels effectively sandwiched by this is a parcel effectively sandwiched by these unique city uses, and probably a more appropriate use for this type of soil. This is a logical transition. The area is already functioning as an edge urban environment. MAU or MUA 10 classification is consistent with surrounding land patterns. I sit here in support of the Jaros property application and rezoning. Thank you for your time.
Thank you for your testimony.
Is there anyone else that would like to testify in support? And I just want to acknowledge for the attendee online, if you would like to testify, please use the raised hand function. All right, I don't think there's anyone else in support.
Okay, we can move to anyone who signed up in opposition to the application.
Therese, do you want to testify? No. All right, Rory.
Good afternoon, Hearings Officer Brooks. Can you hear me?
I can, thank you.
Great, thank you. For the record, my name is Rory Isbell. I'm a staff attorney with Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon, 97703. We do oppose this application. This subject property is agricultural land protected by statewide land use goal 3. As you've heard, it has a long history as part of a larger 1,400 acre irrigated crop and livestock operation. It does legally have 63 acres of water rights. I'd point you to OAR 660-033-0020 subpart 9, which says that a property within an irrigation district that was formerly irrigated must legally be considered to still be irrigated, even if water rights have been transferred. On the goal 3 issue 2, we've heard a lot of talk about profitability and the potential of this property. I first want to point out that LUB has been clear that profitability is a very minor consideration that shouldn't distract from the other goal 3 inquiry, including the 7 factors under the 660-033-00201AB prong of the definition of agricultural land. But, with that said, I want to note that the application materials themselves demonstrate that the subject property is capable of profitable farm use. And that's because in 2002, Deschutes County approved an application for a farm dwelling on the property. And as part of that application, that applicant had to establish that they had garnered an income from farm use of the subject property. And they submitted evidence of over $32,500 in gross annual income in 2 consecutive years from raising and selling horses on the property. That sort of equestrian use is just one of many farm uses that the subject property is suitable for, as with many similarly situated farm properties across the county. I mentioned this property is part of a historic 1,400-acre Lazy Z ranch. That makes it part of a farm unit. There's another prong of our agricultural lands definition. That's at OAR 66003300201B, which exists for the very purpose of this type of situation, where there's a smaller property that was once part of a larger farm operation, which the law calls a farm unit. And that definition of agricultural land exists to accomplish the state policy of preserving the maximum amount of large blocks of agricultural land as possible. That's at ORS 215243. You've heard about Goal 5. This is part of a larger corridor of protected scenic resources. And assuming that the landscape management zone will continue to adequately protect resources under Goal 5 can't be assumed, because we're introducing new conflicting uses, and the county needs to make a new determination about whether these new uses that weren't considered on this property in 1992 should be allowed, or how they should be protected. I do want to touch on Goal 14 and the related comprehensive plan policy at 3.3.1. Policy 3.3.1 says that minimum lot size for new lots in the county is 10 acres. Well, the MUA zone allows smaller units or smaller new parcels than that, particularly because within 1 mile of an urban growth boundary, the county code says you get a density of 5, a 5-acre density, so a density bonus this close to UGB. And in planned developments, you can have no minimum lot size. So applying the MUA zone to this property would directly conflict with the county comprehensive plan. It would also conflict, we argue, with Goal 14, because allowing that amount of development this close to an urban growth boundary frustrates the very purpose of that urban growth boundary, which is to contain new growth inside an urban growth boundary. I'll stop there. I've already gone over my time. No one stopped me, so I took the liberty to keep going. Thank you for that. I do want to request the record be left open. I am going to go ahead and ask that the record be left open for 14 days. There is great public interest in this application. It's a cherished scenic view. There's almost 1,000 pages of materials that have been submitted by the applicant. I think the public should have a 14-day open record period in order to continue digesting all of the issues that this type of plan amendment zone change application presents. Thank you.
All right. Thank you.
And I'd be happy to answer any questions if you have them.
All right. I have no questions for you at this time.
Thank you.
Is there anyone else in the room that would like to testify in opposition? And for our attendee online, if you'd like to testify, please use the raise hand feature by hitting the raise hand button at the bottom center portion of your screen. So it looks like there's no one else that wants to testify.
Okay. Ms. Lewis, if you want to come back up for a rebuttal period.
Thank you. Again, Tia Lewis for the record, and I'll be brief. We are willing to agree to an open record period, so I will conduct most of that rebuttal during that time period. But I do want to point out a couple things. One is that, like the prior application, the minimum lot size in the MUA 10 zone is not relevant, or the minimum lot size in the county's comprehensive plan is not relevant to the present application, as no development is proposed. And I do want to talk about, the historical farm use of this property establishes exactly what we've been trying to say, which is it's not farmable. And the soils report establishes that as well. But the experience of all of the people that have tried to farm it. We have so much testimony saying that they really did everything they could. There were soil amendments, there was regenerative processes, there were seasonal grazing, there was trying to grow a crop, or there's not any agricultural infrastructure on this property. And so every expert who's looked at this property has said that the returns that would be made from farming this property, even if there were water, and by the way, the estimate to get water and to install water infrastructure for the property is $1.5 million. But let's just assume that you could get water. Every expert who's looked at it says that the returns are insufficient to offset even the basic costs of taxes, of landholding, of taxes, of fencing, of maintenance, of labor, of feed, of irrigation, and operational risk. And our county suffers because unproductive land stays in EFU. This land is in farm tax deferral and is not supporting agriculture. And our scarce water resources are being applied to unproductive land to retain water rights and prevent forfeiture and to support farm tax deferral. Again, that's not supporting agriculture. And so hobby farmers and large landowners get to pay less taxes. And if these 300 people that wrote in opposed to this were told the real story and actually looked at a picture of the actual property that's the subject of this application, they might think differently about whether or not they oppose something like this. And we could, if they want to protect open space, then let's do that. But agricultural zoning is not that process. And scenic resource zoning, overlay zones, is not that process. Deschutes County Comprehensive Plan prioritizes the preservation of high-value farmland. It prioritizes the efficient use of limited water resources, and it prioritizes land use designations that reflect the actual land capability. Continued agricultural zoning is in conflict with these comprehensive plans' core objectives, and maintaining agricultural zoning under these factors does not preserve meaningful farm activity, and it does not advance county agricultural resiliency or sustainability goals. Instead, it squanders scarce land and resources and keeps land in a zoning category that doesn't reflect the land's characteristics. We've shown you that this land is not agricultural land. We've shown you that the MUA 10 uses are consistent with the Goal 5 scenic protections, and we request that you recommend approval of the application. Thank you.
Thanks. I do have one question for you, and you're free to do this in writing since we're going to leave the record open, but I'm curious what your response is to the fact that on the same property, the farm dwelling was based in part on the farm income.
Yeah, that farm income was based on the 1,400-acre Lazy Z Ranch where those horses were raised, but I can do that in writing.
Thank you.
Again, that was many years ago.
Okay. And just to clarify, it sounds like you're okay with the open record. Is that including the request that it be 1477?
No, I object to the 14 days. We would like the 7, 7, and 7, which is authorized by statute and Deschutes County Code. We submitted this application in February. We have not supplemented it since that time. So anybody who wanted to comment on it has had ample time to review it.
Thank you. I don't have any other questions for you. I'm going to ask staff if they have any final comments, and then I'll address the record period.
Thank you.
There are no additional comments from staff. Thank you.
Okay, thanks. Well, with that, I agree. I'm going to allow the written record to remain open. I don't see a reason to do it beyond kind of the normal 777 period, which has been sufficient in most cases. And again, I think it's the open record period is not to allow new participation, but to let the parties who have already been here and weighed in on the application to refine their positions as needed based on what's been developed to this point. So I'm going to stick with that. And so just for everyone's information, as a reminder, the first 7 days is open to any of the participants to submit new evidence. The second 7-day period is for rebuttal evidence only that responds to the new evidence that comes into the record. And then the third 7-day period is for the applicant only to make a legal argument with no new evidence. With that, Ms. House, do you have new dates calculated for that?
I believe these are the correct dates that were previously discussed. So a new evidence and testimony deadline will be Thursday, May 28th at 4 p.m. Rebuttal evidence and testimony will be Thursday, June 4th at 4 p.m. And final argument by the applicant, their deadline will be June 11th at 4 p.m. And again, I'll state on the record, I will be out of office, but I will have someone monitoring my inbox. So that should be uploaded for the hearings officer's consideration shortly after it's received, if it's received on the 11th. And just a few additional notes on submittals, if I can get my slide to advance. All submittals should be directed to me. My name again is Caroline House. My email is caroline.house@deschutes.org. And any submittals need to be actually placed in the record, so no links to websites. Put the actual information on the website into the record. And we do not retrieve any information from a cloud storage system. And make sure you get submittals in before the 4 p.m. deadline. That needs to be received by the county server by that deadline. And sometimes there can be a delay between when you send it and it's received. That's everything I was going to cover.
All right. Thank you. I appreciate everyone's time today. I'm going to close the close the hearing for this matter. We're going to leave the written record open as just described. And we will go off the record now. It is 2:59.